In this lesson, we are going to be looking at the final element of the area of subject relating to the formalities of a trust. Now, unfortunately, we have to essentially go and dive into what is considerably, at least in my opinion, one of, if not the most convoluted and difficult topics in all of law, never mind just the law of trusts. But don't worry, it's only going to take us 2 lessons to try and get through this convoluted area. And really, think of this as the just reaching the peak of the mountain when it comes to the law of trusts. Is if you can get over this bit and you can get to understanding this bit and you can just at least know what you're talking about when thinking about this, then it is all downhill from here, because next topic is going to look at charitable trusts, we'll look at implied trusts, and then we'll look at the duties of trustees and breach of trust. These are all much nicer topics that are not as convoluted as what this particular area is. So we're going to be talking about the disposition of equitable interests and trusts in land, and it doesn't even just necessarily require an understanding of trusts in land. Fundamentally, we examined the formalities that were in place regarding the creation of a trust in land. We're going to talk now about some of the subsidiary considerations in relation to trusts and the formalities of trust. One being, of course, requiring looking at equitable interests in relation to trusts. We'll talk about the general rule in this lesson, and then we will talk about something known as the Van der Waal exception in the next, which is a particularly convoluted series of cases, in fact, and illustrates a point that requires there to be some kind of exception to this particular rule. So how do we deal with equitable interests when thinking about the formalities of a trust? It's a particularly convoluted topic, as I mentioned. Simply put, what this topic involves our understanding is of how to deal with situations where there are formalities in place which govern the creation and the disposition of an equitable interest in land. Now, this is something that is governed by Section 53(1)(c) of the 1925 Law of Property Act. Because what Section 53(1)(c) says is, quote, a disposition of an equitable interest or trust subsisting at the time of the disposition must be in writing signed by the person disposing of the same or by his agent thereunto lawfully authorized in writing by will. Now, the points of note to take here is that this idea will actually apply to any type of property which has a beneficial interest. It doesn't necessarily just apply to land, and so when we look at some of the case law in this area, it doesn't actually the facts of the case doesn't actually pertain necessarily to trusts that are created on the basis of land, but in fact are created for other reasons, for different properties, whether that be money, shares, etc., etc. That's one point of note. When we think about the idea of subsisting at the time, which is considered in this part here, in the first line of Section 53(1)(c), where it says a disposition of an equitable interest or trust subsisting at the time of the disposition. What do we mean by this? Well, what we are talking about here is that the provision and the wording therein applies not at the creation of the trust, but at the point at which there already exists a trust. I.e., a trust in existence is considered to be the idea of subsisting. So when we say subsisting at the time, we're talking about a trust that already exists at the time of the disposition. And there is a desire at that point to make a transfer that will benefit another. If a trustee is directed to hold property on trust for another, this represents a disposition of a subsisting equitable interest in that title, because the subsisting equitable interest is obviously the existing interest, the existing equitable interest in the title in question. This is something that is confirmed in the case of Gray versus the IRC. If you're keeping up with this, then well done to you. Again, if you don't understand this topic, it might be more useful to watch this in conjunction with maybe the textbook chapter, whichever textbook you have on this particular area, because this might give you, this might be a way of helping you understand the topic, but then you go into it in more detail with that chapter. So the case of Gray versus the IRC from 1960 was a case that involved a settler who was a grandfather and who had made a number of settlements in favour of his grandchildren. A number of shares were then transferred to the trustees, who would then hold that property on trust for his benefit. Later, he, by way of oral instruction, would tell his trustees to hold the shares on trusts of the settlement for his grandchildren. This was all done in accordance with the required formalities to properly constitute the trust. So all of the formalities were in place, the constitution of the trust was perfected, etc., etc., etc. All of those areas were at least done in accordance with those required formalities. The question for the House of Lords, though, was whether or not a transfer had actually taken place. And this was obviously important because, in relation to the IRC, because there were potentially tax implications. Obviously, IRC is related to the inland revenue. They concluded that there had been a transfer. The oral direction that had been given by the settlor to the trustees represented a disposition of a subsisting, remember subsisting just means existing, already existing, equitable interest, as therefore for the purposes of section 53(1)(c) of the Law of Property Act of 1925. Viscount Simmons concluded that if one were to give disposition its ordinary meaning, it would be concluded that it represented a, quote, transaction whereby a beneficiary who has a beneficial interest at the beginning of the transaction no longer has it at the end of the transaction. This is what we mean by disposition. We have a beneficial interest at the beginning that no longer exists, or at least we no longer have at the end of the transaction. There has been a disposition that has taken place there, and it has been a disposition of a subsisting equitable interest, an already existing equitable interest. This was the case here. They go on to say at 16 that something had to happen to that equitable interest in order to displace it in favour of the new interest created by the direction. Remember, the direction in question that we're talking about is the oral instruction that was told to his trustees to hold the shares on trust for the settlement of his grandchildren rather than for his own benefit. So something had to happen to that equitable interest in order to displace it in favour of the new interest created by the direction. And it would be at any rate logical to treat the direction as being an assignment of the subsisting interest. So if you don't understand this topic, we will go into it in more detail in the next lesson, because we're going to start in the next lesson to think about the Van der Waal exception to this particular rule, the Van der Waal exception to this area, and the ways in which the Van der Waal cases actually fit into the area relating to formalities of trusts. And then from there, like I said at the start of this lesson, it is all downhill in terms of ease of understanding. I don't particularly like this topic, so if you don't understand it or don't particularly like it, then don't feel bad. I believe the textbook that I referenced, or one of the textbooks that I referenced in making this lesson, suggested that this topic is a sore point for teachers of trusts the country over, every single year having to teach this area. So don't feel bad if you don't understand it. We'll get into the Van der Waal exception in the next lesson.